I imagine the first thing they do is send them a letter saying, we want our money, maybe
demand letter.
Call them up a couple times and things like that. But at some point, they're going to come to you and say, Stuart, we want our money and we want it now. What can you do to help us? So what can you do?
Well, the first thing I would do is send a demand letter by certified mail, return receipt requested.
All right. And why would you do that?
Evidence that I actually tried to communicate with them before filing a lawsuit.
And send the same thing, regular mail as well?
Absolutely.
Just in case you don't want to pick up their certified mail?
Absolutely.
All right. And what would your letter say?
Please be advised that this firm has been retained by the Daily Planet with reference to an outstanding bill for services that they have rendered to you.
Mm-hmm. Now, what else would you say?
That they have 30 days to pay the bill. Otherwise, that bill is going to be the subject of a lawsuit, which could involve more money being owed because of attorney's fees, court filing fees, and other relief that the court may or may not give.
Now, everything you've said so far is 100% legally accurate.
Yeah.
And I noticed that you left out the part where you're supposed to say, and also we're going to file criminal charges against you unless you pay. That would probably be an RPC violation, I would imagine, right?
Yes.
So you should be avoiding utilizing references to criminal stuff, right?
Yes, unless the only time that I would say that that is not correct is if you're dealing with something like a kiting charge, where someone purposely gave you a bad check.
Right.
And then, yes, there are criminal sanctions for kiting.
Okay. Here's my advice to the lawyers that are out there, okay? So all of you listen to me very carefully, because I've been through this, not personally, but representing guys who've done this. I mean, nothing will make you more angry than a client who will either stick you for a fee or, worst of all, you go, you represent them on an emergent basis, you show up, you do a good job, and then the check bounces, okay? And they won't pay, and they won't pay, and they won't pay. And I've seen attorneys who write demand letters to them, but they put in there, they threaten to utilize the criminal process to collect what is basically, a civil debt. I mean, they can make all the argument they want that it's theft of services and a check problem and all that other stuff. But my sense is you're really violating the RPCs by doing that. If you're serious about it, you should just go down and file a criminal complaint and let that be the end of it. And don't give them any notice. I mean, if they've committed the offense, and there's probable cause to believe they've committed the offense, you're entitled to go to court and have your matter prosecuted. Do you agree?
Yes.
Okay.
But I would say this, if we're talking to attorneys, that the attorneys are under a special obligation under the court rules. An attorney must give the potential defendant, the person that failed to pay the bill, their client, the option to go to fee arbitration.
Right.
And if you do not give that, the court will throw out your lawsuit. So you have to send that fee arbitration notice in your demand letter, give them the 30 days before you file that lawsuit.